Assalamualaikum warahmatullahi wabarakatuh and greetings. We are from group 2. First, we will start with the introduction of our group member.
I'm Mardhiyyah Binti Nordin.
My name is Syaeidah Binti Madzhar.
My name is Hazwani Binti Hilmi.
My name is Nurin Hidayah Binti Hadi.
My name is Nurina Arwa Binti Lukman Hakim.
This presentation is for the partnership agreement of QUINATE. This partnership agreement is made and entered on the 1st January of 2021 by and between Nur Aini Syaeidah binti Madzhar, Nurin Hidayah binti Hadi, Nur Hazwani binti Hilmi, Mardhiyyah binti Aziz Nordin, and Nurina Arwa binti Lukman Hakim on behalf of Furniture, and this is the address stated in the agreement. Hereafter, all the parties above shall be referred to as the partners of the agreement. Section 1 state about functions of the partnership. In accordance with the terms, conditions, and covenants of this agreement, the partners shall form a general partnership for the purpose of, in accordance with the Partnership Act 1961. The partnership shall operate under the name of QUINATE Furniture. The partnership shall begin on the effective date of 1st May 2020 and shall last for a term of 15 years. The purpose of the partnership shall be to oversee, manage, and otherwise facilitate the following business functions involving designation, craft, distribution, and sale of functional and decorative objects of household equipment. All decisions shall be made by the partners who control a majority of the capital of the company, except as otherwise deemed appropriate by the partners. And meeting between the partners shall be held at regular intervals of once a year for the partnership agreement duration. Section 2 state about capital, profit, and loss. Each of the listed partner shall total to the partnership as listed below. All capital contribution will be deposited into a joint capital account and shall be regularly balanced in accordance with each partner's share of the partnership profit and loss. The partners shall deposit the funds into a special bank account, which is Maybank Berhad of Kuala Terengganu. Profit or loss resulting from the function of the partnership shall be deposited or withdrawn from the special bank account. Each partner shall provide a bank account for their own contribution, which profit or loss shall transact to or from once a year interval in proportion to the value of their respective contribution. And the balance of the special bank account shall constitute the cash on hand of the partnership for all purposes, including but not limited to taxation and valuation.
Next, we move to partnership management. The partners designated Nur Aini Syaeidah binti Madzhar as the executive responsible for the day-to-day operation of the partnership. Second, the executive shall see the maintenance of record and books consisting of all account balances, assets, liabilities, and all other revenue information pertaining to the partnership. The partners reserve the right to inspect, audit, or otherwise request to the partnership records and books at any time. It is the responsibility of the executive to make the records available on demand at the will of the partners. Any changes in the ownership will be handled by the consent of majority partners. The executive will be responsible to handle if any unexpected event arises during the business management. Any dispute arising between the partners shall be settled by the Malaysian Arbitration Association, and the judgment upon the award rendered by may be entered in any court with jurisdiction thereof. Next, annual audit. The partnership shall conduct a complete and thorough audit of all accounts, records, and books of the partnership on a yearly basis. The annual accounting of the partnership shall occur within the first meeting of each calendar year at a time determined by the partners. All financial records shall be reviewed at minimum of semi-annually and at the request of the partners throughout the year. The annual accounting of the partnership shall occur within the first meeting of each calendar year at a time determined by the partners.
For Section 5, additional partners may be added at any time upon the unanimous written agreement of the existing partners, so long as the total number of partners does not exceed 20 partners. For Section 6, provided the share in a partnership or assignment, any partner may assign his share upon giving written notice to the other partners. For Section 7, partner removal, a partner may be removed as deemed necessary only by a majority vote of those partners a controlling share of the capital of the partnership. Any such partner shall be notified in writing of their removal. Any partner removed from the partnership shall be paid for all contribution minus any liabilities incurred and plus any gains or interest he or she is entitled to immediately upon removal from the partnership. Section 8. For partner withdrawal, any partner may withdraw in part or in full from the partnership at any time. Notification of withdrawal must be made in writing. Funds shall be withdrawn from the special bank account of the partnership, shall be based on the most recent valuation of the partnership at the time, and shall be transferred to the withdrawing partner's bank account of record. The partnership shall continue to function as a taxable entity so long as enough capital remains to do so, regardless of individual partners' withdrawals.
Section 9. Termination. This partnership shall terminate upon the death, bankruptcy, or incompetency of any partner. In such cases where there exist more than two partners in the partnership, the remaining partners shall act as a trustee on the former partner's behalf and shall promptly wind up the affairs of the partnership unless the remaining partners agree that they will continue the business of the partnership. By agreement of all partners, the partnership may be dissolved, in which event the partners shall proceed with reasonable promoters to liquidate the business of the partnership. The assets of the partnership business shall be preferred as payment of all partnership to duties, taxes, and fees to the state, and to provide payment for liabilities liquidating other expenses and obligations. Second, equalize the income accounts of the partners. Third, discharge the balance of income accounts of the partners. Fourth, equalize the capital accounts of the partners. And fifth, discharge the balance of the capital accounts of the partners. Where the dissociation of a partner to any reason result in the dissolution of the partnership, then the partnership will proceed a reasonable and timely manner to dissolve the partnership with all debts and obligation being paid first. Prior to any distribution of the remaining funds, the remaining partner retain the right to seek damages from a dissociated partner when the dissociation resulted from a malicious or criminal act by the dissociated partner, or where the dissociated partners had breached their fiduciary duty to the partnership as provided for in this agreement, or had acted in a way that could reasonably be foreseen to bring harm, damage, or mailing the reputation of the partnership. Prior to termination of the partnership, all partners are to be advised in writing that termination is being considered no fewer than 10 days before the termination may transpire. Upon the decision to terminate the partnership, all partners shall be notified by the executive immediately. All assets shall be distributed accordingly to all partners upon the termination of the partnership. Repayment shall correspond to the percent contributed by each respective partner, except as outlined elsewhere as applicable. Payment shall be made to the bank account of record for each partner upon dissolution of the partnership. Section 10. Death of a partner. Upon notification of the death of any partner, the notice shall be treated as a full withdrawal from the partnership. At such a time, all contributions and all other funds owed to the partner shall be transferred to the designee, agent, or trust of the deceased partner's choosing.
So the next section, which is the payment, all withdrawals may be made in cash or securities, or some combination at the discretion of the drawer. In cash transfer, the drawer is entitled to an amount equal for the lesser of 5% of the value of the capital account being withdrawn from the value of the capital account, less any cost incurred in the transaction of cash or securities. For securities withdrawal, a third-party broker shall be used. The drawer is liable for brokerage fees resulting from the withdrawal. And the next section, relation of the partnership. For the term of this partnership agreement, first, Each partner shall be just and faithful to the other, and shall devote her best effort and the whole time and attention to the partnership business. Second, each partner shall be entitled to take 1 week's holiday each year at times agreed by the other partner. Third, neither partner, without the consent of the other, engage in any business or other than the partnership business, or lend any partnership money or property, or become bail or guarantor for any person, or release any debt due to the partnership, except in the ordinary course of business, draw, accept, or endorse any check or other bill exchange, or give any security or promise for the payment of money. And the last section is any notice given by either of the partners shall be served by personal delivery or by registered post to address of the other partner as set out as in this agreement, or as notified for the purpose from time to time. Any such notice shall be deemed to be effectively served in the case of registered post 48 hours after it has been placed in the post. This partnership agreement shall be binding upon the signatures of the partners. So that's all from us. Thank you.